I'm James Chadwick. I'm here for the California First Amendment Coalition to talk to you about the Ralph M. Brown Act. What is the Brown Act and what does it do? The Ralph M. Brown Act is referred to as the Brown Act, and its purpose is to provide public access to meetings of local government agencies. It's part of California statutory law. It's in the California Government Code beginning at section 54950. So what does it do? The main provisions of the Brown Act are these. The Brown Act generally requires that meetings of local government bodies be open to the public unless they're closed for specific reasons, such as to discuss pending litigation or to instruct the local government body's negotiators in real estate transactions. It's important to keep in mind that one of the fundamental purposes of the Brown Act is to prevent public bodies from deliberating outside of the public realm. They're supposed to make their decisions in public, and that means they're supposed to discuss and deliberate on those decisions in public. The Brown Act also requires advance notice of all meetings, whether they're open or closed. The Brown Act requires agendas for all meetings, and it prohibits public bodies from talking about topics that aren't on the agenda. The Brown Act ensures that the public has the right to address local government bodies about both matters on the agenda and other matters of concern to the public, including criticism of a government body or its members. The Brown Act also provides a mechanism for enforcing these requirements. The Brown Act applies to cities, counties, school districts, community hospital districts, all kinds of local government bodies. The Brown Act does not apply to state agencies. The Bagley-Keene Act governs state agencies instead. So what are legislative bodies? Who are these legislative bodies that are subject to the Brown Act? Typical examples are city councils, local government redevelopment agencies, school boards, community hospital boards, any multi-member body that governs a government agency and its actions. Most commissions and committees and boards created by these kinds of legislative bodies are also covered by the Brown Act. So if the city council sets up a committee for a particular purpose, that committee has to comply with the Brown Act as well. So any committee, board, or body created by a city council, a local school district, a redevelopment agency, these kinds of bodies also have to comply with all the requirements of the Brown Act. Some boards of local nonprofit entities may also be subject to the Brown Act if they've been created to serve a governmental function. So for example, the governing body of a special local assessment district that controls funds collected from local property owners is subject to the Brown Act. What kind of notice is required? One of the fundamental purposes of the Brown Act is to make sure that people understand that a meeting is going to be held and what it's going to discuss. Advance notice of meetings is required by the Brown Act, and in general, the Brown Act requires at least 72 hours notice of a meeting. In general, that means the agenda for any meeting has to be published 3 days in advance. There's places to look for these kinds of agendas. Sometimes they'll simply be a paper agenda posted on a bulletin board at City Hall, but more and more governments are posting their agendas online. So find the website for your local government agency and look for the agendas there. One of the things you can do to improve public access to local government meetings is to ask for better notice. A lot of times, 72 hours may not be enough notice for a particularly controversial or complex subject. There's nothing to prevent you from pressuring your local government to provide you with better notice. Several cities in California have local sunshine ordinances that require up to 10 days notice. The other important thing to look for in advance of the meeting is the agenda itself. The agenda has to be posted publicly, and it has to provide an adequate description of every item that will be discussed at the meeting. That generally means a short but accurate description. And if you've been to public meetings, you know that this rule is sometimes honored more in the breach than in the observance. It's important to put pressure on your local government body to ensure that it has accurate descriptions of every item to be discussed at a meeting included on the agenda. The agenda itself is typically not the only document that's provided along with the public meeting notice. There is a whole agenda packet that's included. Generally, documents that are provided for consideration by a public body have to be made available to the public. These documents are usually described as the agenda packet. And the agenda packet is something that you can ask to have mailed to you in advance of the meeting. It's also something that should be available at every meeting. And increasingly, these agenda packets are also available online. So you can download the staff memo, for instance, that will be provided to the City Council with respect to a redevelopment project that's being discussed. It's always, again, important to keep pressure on the local government to give you the best access possible. It's really difficult to participate meaningfully in the discussion of any topic if you don't have the same information that the city has. So put pressure on the city or the other local government agency to give you access to everything that's going to be in the agenda as soon as possible, certainly not later than the agenda is posted, and to put that material online as much as possible. So there are some key provisions of the Brown Act that are designed to ensure that public meetings are meaningful. That is, that you don't just go in there and see a bunch of decisions that have been made in advance announced on the public record. One of the key provisions is that the Brown Act defines a meeting in a way that tries to prevent local government bodies from deliberating or deciding issues outside of the public view. There can be no serial meetings. Serial meetings or deliberations are a process by which one member of a city council, for instance, or a city manager meets seriatim, one after the other, with all of the members or with just a majority of the members of the city council in order to arrive at a consensus or simply in order to inform them all about an issue, even if they don't arrive at a decision. That's exactly what the Brown Act is intended to prevent. Those kinds of deliberations are supposed to be out in the open for all of the public to see and participate in and understand. It also applies to email communications, telephone calls, any kind of mechanism that's used by a public agency to develop a consensus or to deliberate on an issue that is the subject of its official ongoing deliberations. It does not prevent members of a local government from meeting one-on-one with members of the public. So you should not be afraid or concerned about approaching your city council member, your redevelopment agency board member, and talking to them about the issues of concern to you. Nothing in the Brown Act prevents that. It does not prevent one-way advice from the staff to a member of a public body, so they can still receive the information they need from their staff in order to do their work. It does not prevent communications involving less than a quorum. So if you have a 7-member board, less than 4 of those members can still meet and talk about matters. What they can't do is use each other to develop a consensus involving more than a majority. So you can't have 3 people meeting and then one of those people going off and meeting with others. The whole idea is to make sure that decisions and deliberations are public, and any mechanism that's used to circumvent that is contrary to the Brown Act. The other important thing that the Brown Act does to make sure that you have meaningful public meetings, that you see what's really going on, is it prevents public agencies from discussing matters that are not on the agenda. So they can't take up a matter and suddenly decide it without warning. And that's the fundamental purpose of the Brown Act. This doesn't mean that they can never talk about anything that's not on the agenda. Basically, the Brown Act gives them the right to respond briefly to public comments that are made that may not refer to something on the agenda, to ask a question about a comment that's been made about something that's not on the agenda. And it clearly allows the public to address matters that are not on the agenda, because otherwise, for instance, the public would have no way of ever getting anything onto the agenda. Legislative body can also address matters that are not on the agenda in one other circumstance, and that's really where there's an urgent need. There is an emergency of some kind that requires practically immediate action. So if there's a work stoppage, a strike, if there's some kind of crippling activity that's going to impair public health or safety, then they still have to give notice, but they can give less than 72 hours notice. Sometimes it may be as little as an hour's notice where they try to get the notice out through the media, but they can still come together and make a decision to take action on those kinds of urgent matters. The other fundamental aspect of the Brown Act and its assurance that the public can meaningfully participate is the guarantee that it gives to the public to speak at public meetings. Every public meeting must include an opportunity for public comment. In general, before the city council or the other public body can take action, final action on an item, it must give the public an opportunity to address that item. So it can't take action on the item and then allow you to address it, which obviously wouldn't be very meaningful. One other thing to keep in mind, although it's not in the Brown Act, it is part of California law. In general, the things you say in a public meeting, such as a city council meeting or another Brown Act governed meeting, are privileged. That is, you can't be sued for the things you say. You shouldn't be too worried about being timid, about being shy, about saying what you mean, about bringing controversial information to a public body, because as a general rule, those comments are not going to be something for which you can be sued. So I mentioned earlier that there are circumstances in which meetings can be closed to the public. I want to talk a little bit about those circumstances, the circumstances in which the public can be excluded from meetings of legislative bodies. There are a few primary exceptions. I won't touch on all of them. First, the real estate exception. Meetings of a public body with its representatives, its negotiators who are representing it in a real estate transaction can be closed to the public. It's important to keep in mind, though, that the only purpose of those meetings is to instruct the negotiators with respect to the price and terms on which real estate will be purchased, sold, leased, or exchanged. So there are often circumstances in which a public body may wish to discuss the development of a particular parcel, may wish to discuss whether or not real estate will be purchased for the purposes, for instance, of locating a public facility, such as a public works department, a stadium, something of that nature. Those kinds of meetings are not the kinds of meetings that can be held in closed session. It's only once they've actually entered into negotiations with another party for the purchase, sale, lease, or exchange of real property that they can actually go into closed session. And then they're only supposed to talk about price and terms, not what might be done with the property, not how the property might be developed, just price and terms. Another important exception is the pending litigation exemption. Public bodies are often involved in litigation, and they're entitled to go into closed session to discuss litigation with their attorneys. Basically, the requirements for holding a closed session to discuss pending litigation are that there is actually a lawsuit that exists, or there is a real threat of litigation. Public bodies can go into closed session to discuss litigation they may initiate, as well as litigation that may be brought against them. It's also important to keep in mind that they're only supposed to be meeting to discuss litigation with their attorneys. It's not just for the purpose of going into a closed session to talk about litigation in general. Another important exemption is called the personnel exemption. The public body can meet in closed session to discuss the appointment, employment, evaluation, or performance, discipline, or dismissal of a public employee. So basically, if you're hiring, if you're firing, or if you're disciplining a public employee, the public body can go into closed session to discuss that. any evaluation of the performance of a public employee is something that can be discussed in closed session. Keep in mind, however, that members of a public body who are elected, such as members of a city council, are not public employees. They cannot go into closed session to discuss any evaluation or discipline of a member of the public body itself. And that's a situation that comes up frequently. Often, public agencies will try to go into closed session or will use that exemption as an excuse to discuss criticisms, for instance, by staff members of an elected official. That's not a legitimate reason for holding a closed session. The last significant exception is called the labor exception. That's a generic phrase for any meeting that the public body has with its representatives in collective bargaining negotiations. Most public agencies have union employees. They negotiate their agreements with unions on a regular basis, and they're entitled to go into closed session for the purpose of holding those negotiations with their representatives in the collective bargaining sessions. They're not allowed to simply discuss collective bargaining issues generally. Is this a good union? Is this a bad union? Has the union engaged in some kind of misconduct? Is there a dispute with the union? Are the employees of the union upset with the city? None of that's an appropriate subject of a closed session. The only purpose of this kind of closed session is to actually talk about the terms on which the agreement with the union will fully be concluded. The Brown Act requires that after a closed session, certain information has to be made public. Any final action taken in a closed session, the approval of a real estate transaction, the approval of a collective bargaining agreement, the settlement of a piece of litigation, all of those matters have to be discussed in public after the final action taken by the city is approved. Any document that is approved by a public body in a closed session, a labor contract, a real estate contract, a settlement agreement, those documents have to be made public after the closed session. It's important to keep in mind that although this is a requirement of the Brown Act, it may not always be observed. So if a closed session is addressing a circumstance, a situation, a negotiation that you're concerned about, don't be afraid to ask if any final action was taken in the closed session. There are enforcement provisions in the Brown Act. It's not a toothless law. If you believe the Brown Act's been violated, insist on compliance. It's important to do that very quickly. One of the catches in the Brown Act is that generally you have to bring any violation to the attention of the public body in a very short period of time. It may be as little as 15 days. So don't sit and wait if you think a violation has occurred. Consult the Brown Act, look at the provisions of the Brown Act. If it's particularly something that you believe needs to be redone, you want the city to reverse an action taken by the city council, you want the school board to reverse an action that it's taken, then you have to provide what's called a cure and correct letter, and that must be done within 15 days. So you don't have a lot of time to wait, but do insist on compliance. You don't have to do everything perfectly. You don't have to be a lawyer to enforce the Brown Act, at least to the extent that you can bring violations to the attention of a local body. Be polite, but be persistent. That's my other golden rule for enforcing the Brown Act. Don't give up, because in general, public agencies' first response will be to tell you that you're dead wrong. Generally, it's not that simple, and often you're absolutely right, but that doesn't mean that a public agency equipped with lawyers won't be arguing to you that you're wrong. Be persistent. Don't give up. Make sure they explain their reasons. Make sure you understand their reasons. There are agencies, such as the California First Amendment Coalition, that can help you. If you've got a question, the California First Amendment Coalition has a hotline. Just go to www.cfac.org and look for the action line. You can send a question to the California First Amendment Coalition, and an attorney with experience in this area will help you answer your questions. Finally, if you have to enforce the Brown Act, if there's nothing you can do except take it to court, see if you can't take it to court. I encourage you to go out and try to find an attorney who can represent you. Again, the California First Amendment Coalition has a service that will allow you to send out a request that will be circulated to experienced open government attorneys throughout the state. Many attorneys may be willing to consider your case because there is a provision in the Brown Act that allows you, if you prevail, to recover your attorney's fees. So don't give up just because the city won't respond to your letters. You still may have a recourse. Thank you.